Hello, everyone. Welcome to the U.S. Immigration News. For millions of families around the world, the I-130 petition is more than a piece of paperwork. It is the thread that ties them to the hope of living together in the United States. It is the beginning of a journey toward reunification, the promise that a spouse, a parent, or a child can finally join loved ones without being separated by oceans and borders. For years, how quickly or slowly this petition moved through the system has been one of the clearest measures of how well America's immigration system is functioning. And today, in September 2025, that measure shows a system weighed down by delays, stricter requirements, and heavier uncertainty than families have faced in years. In this video, we'll walk through the reality of I-130 petitions right now, how the Trump administration has reshaped the rules, how processing timelines have stretched, and what this all means for families who are holding on to the hope of reunion. If you are liking this video, please hit the bell button, subscribe, and like it, so that you may get updates straight to your smartphone. Now let's get into the video. For anyone trying to understand why the current situation feels so difficult, it helps to look back just a short time. Under the Biden administration, USCIS made reducing backlogs and improving efficiency a top priority. After the chaos of the pandemic years, the agency created what were called cycle time goals, aiming to process most I-130 petitions for immediate relatives in under 12 months, while family preference petitions were targeted for completion within 2 to 3 years. To get there, they hired more staff, pushed through technology upgrades, and in many cases, waived interviews for low-risk cases that didn't need that extra step. By late 2023 and into 2024, many families began to feel the change. U.S. citizens filing for their spouses were often seeing approvals in 10 to 13 months. An adjustment of status cases filed alongside the I-485 sometimes moved even faster. While the system wasn't perfect, there was momentum, and people felt like something was finally working. That fragile progress came to a halt in January 2025, when Donald Trump began his second term. Almost immediately, his administration shifted the focus of USCIS away from backlog reduction and toward what they called security and integrity. Executive orders and policy changes introduced new layers of scrutiny, paused certain categories of adjudications, and reinstated enforcement-heavy practices that had been rolled back during the Biden years. Families that thought they were nearing the finish line suddenly found their cases slowed or pushed into new uncertainty. As of today, the numbers speak volumes. For immediate relatives of U.S. citizens, that means spouses, unmarried children under 21, and parents, the average wait for an I-130 approval has stretched to about 14 to 15 months. Just 2 years ago, many families in this category were celebrating approvals several months earlier. For permanent residents filing for their spouses or children, known as the F2A category, the delay is even more punishing. The typical wait now is close to 35 months, almost 3 full years before the petition is even approved. And for the broader family preference categories, adult children or siblings of U.S. citizens, the situation can feel almost hopeless. While USCIS may approve the petition within a few years, the visa bulletin backlog adds many more. Applicants from high-demand countries like Mexico or the Philippines are staring at waits of 6 years or more, with some cases stretching toward a full decade. These are not abstract figures. They are years of separation, of parents missing milestones in their children's lives, of spouses celebrating anniversaries apart, of families living on video calls while they wait for the US system to open its doors. Why has this slowdown taken hold? The reasons lie in policy changes that ripple through every application. One major shift is the return of broader interview requirements. Under Biden, many cases that were clearly low risk were approved without an interview, saving time for both families and officers. Under Trump, those waivers have largely disappeared. Now, even straightforward petitions are being routed to interviews, clogging up schedules and adding months of delay. Another key change is the tightening of financial requirements. Sponsors are being asked to provide more documentation. Multiple years of tax returns, pay stubs, property records, and proof of assets. Officers have been directed to scrutinize these submissions closely, and any gap, inconsistency, or missing page can trigger a request for evidence. These RFEs are becoming far more common, and they set cases back by months at a time. Even small clerical mistakes can result in major setbacks. Requests for evidence and even notices of intent to deny are not only more frequent, they are being issued for reasons that previously might not have held up a case. A translation without the right certification, a single typo in a date, or a missing signature on a supporting page. Things that, in earlier years, could be fixed informally, now result in long delays. Immigration lawyers around the country report that families are scrambling to resubmit documents and losing precious time because of this rigid approach. On top of that, USCIS has broadened its review of character and security. In August 2025, internal memos made clear that the definition of good moral character is being interpreted more broadly. Officers are looking beyond criminal records into public conduct, behavior, and even, in some cases, social media presence. This has created a new sense of fear and unpredictability for families who thought the I-130 process was simply about proving a qualifying relationship. Now, they feel they are being judged on factors they cannot fully predict or control. For families, the impact is heartbreaking. A US citizen who files for a spouse may now wait 15 months for approval, then face more months at the National Visa Center before an interview can even be scheduled abroad. A green card holder sponsoring their child must prepare for nearly 3 years of waiting before USCIS even finishes its part of the process, followed by additional years of waiting in the visa queue. Parents miss graduations, children grow up apart from one parent, and families lose time together they can never get back. The promise of family reunification feels further away than ever. The strain is not only on families, but also on the immigration system itself. Because USCIS is funded almost entirely by application fees, long backlogs and growing delays can push families to postpone filing, reducing the agency's revenue. At the same time, officers are burdened with heavier caseloads and more demanding requirements, creating a cycle of stress that slows the system even further. When fewer petitions are approved quickly, fewer move forward to the National Visa Center, and consulates abroad also feel the strain. The entire system becomes gridlocked. Comparing Biden and Trump makes the divergence clear. Biden's approach centered on efficiency, transparency, and reducing the crushing backlog. Interviews were waived when unnecessary, timelines were posted publicly, and families could see movement on their cases. Trump's second term has swung the pendulum back toward enforcement and suspicion. Every case is treated with heavier scrutiny. Every sponsor must prove more, and every applicant faces deeper checks. The result is not greater clarity or fairness. It is longer waits, heavier burdens, and rising uncertainty. Looking ahead, the future of I-130 petitions will depend on several factors. Lawsuits challenging some of the stricter requirements are already in the courts. Advocacy groups are pushing Congress to intervene, warning that the family-based immigration system is on the brink of collapse if delays continue. Supporters of Trump's policies argue that these steps are necessary to protect national security and prevent fraud, even if it means longer waits. But for families caught in the middle, the debate feels abstract. What matters is time. Time they cannot get back. Time spent separated when they should be together. So where does this leave those filing petitions today? The reality is sobering. Families must be prepared for longer waits, more paperwork, and a greater risk of delays from RFEs or denials. Careful preparation of every document, early filing to get in line as soon as possible, and in many cases, the help of an immigration attorney are no longer luxuries. They are necessities. Families must brace themselves for a system that now tests their patience at every step. The bottom line is that the I-130 process in 2025 is slower, stricter, and less predictable than it was under Biden. The system has shifted away from helping families reunite quickly and toward filtering families through layers of suspicion and enforcement. For millions of immigrants across the world, this means patience, preparation, and persistence are more essential than ever on the road to permanent residency. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the U.S. Immigration News Channel. Thank you for watching, and we'll see you in the next video.